Thank you all for joining us here in the theater, and for those of you who are joining us through C-SPAN or on YouTube. We're happy to have all of you join in this evening's program. I'm Jim Gardner, the Executive for Legislative Archives, Presidential Libraries, and Museum Services here at the Archives, and I'm pleased to be able to welcome you tonight on behalf of David Ferriero, the Archivist of the United States. Today has been Magna Carta Day here at the Archives. We've been celebrating the 800th anniversary of the day in 1215 when King John of England agreed to a charter aimed at making peace between him and a group of barons who were in rebellion. Magna Carta established that no one, not even the monarch, is above the law, and everyone has a right to the law. These principles inspired our nation's founding fathers when they crafted our founding documents, the Charters of Freedom, the Declaration of Independence, the Constitution, and the Bill of Rights that are in the rotunda above us. Also on display here at the Archives is a very rare copy of the 1297 Magna Carta. It greets you when you visit our Records of Rights exhibit. As you came in tonight into the Archives, it was right ahead of you, not lit up because the gallery's closed tonight, but I hope you'll come back and see our copy of Magna Carta. The Magna Carta is part of an exhibit called Records of Rights in the David M. Rubenstein Gallery. Mr. Rubenstein provided support for the gallery and even put his copy of Magna Carta on permanent display there. Tonight, we have a panel of Magna Carta scholars who will explore the ties between this historic document and how we live today. However, before we go any further, I'd like to tell you about a couple of evening programs coming up soon here in the McGowan Theater. This Friday, June 19, at 7 p.m., the AFI Docs Guggenheim Symposium pays tribute to documentary filmmaker Stanley Nelson, whose films on the African American experience have received wide acclaim. The program is being presented by the AFI Docs Documentary Film Festival in partnership with the Charles Guggenheim Center for Documentary Film here at the National Archives. Then on Thursday, June 25th at 7 p.m., we'll have a panel discussing D.C. statehood and the current state of our representative democracy. The panel will include former Washington, D.C. Mayor Anthony Williams, D.C. Delegate Eleanor Holmes Norton, and former New York Congressman Jim Walsh. The program is being presented in partnership with the U.S. Association of Former Members of Congress. If you want to know more about upcoming events here and all our public programs, please refer to our monthly calendar of events. Copies of the calendar are in the lobby, along with the sign-up sheet to be included if you want to be included on our mailing list for the calendar, either by regular mail or email. Another way to get more involved in the National Archives is to become a member of the Foundation for the National Archives. The Foundation supports the work of the Archives, especially our education and outreach programs, such as tonight's. You can pick up an application for membership in the lobby or become a member online at archivesfoundation.org. Tonight's program, getting back to tonight's program, will be a discussion of the influence of Magna Carta on American constitutionalism, including its place in the charters of the American colonies, its impact on our founding era, and its continued influence today. This program is presented in partnership with the Constitutional Sources Project, also known as ConSource, and we thank them for their support. The project is a nonprofit devoted to educating lawyers, judges, teachers, students, and the general public about American constitutional history. And with us tonight to open the program is the Executive Director of ConSource, Julie Silverbrook. Julie holds a law degree from the College of William and Mary and a bachelor's degree in political science from the George Washington University. Now, to introduce tonight's panel, please welcome Julie Silverbrook.
Thank you for that generous introduction, Jim. As Jim mentioned, I'm Julie Silverbrook, Executive Director of the Constitutional Sources Project, or ConSource. All right, we're good? Okay.
Sorry.
That's all right? Okay, everybody can hear me now? All right, let's try that again. I'm still Julie Silverbrook, and I'm still the Executive Director of the Constitutional Sources Project, or ConSource. For short, we're an organization devoted to facilitating greater access to and understanding of U.S. constitutional history, and it is an absolute pleasure to join the National Archives this evening to celebrate the 800th anniversary of the sealing of Magna Carta. Magna Carta has left a profound legacy for law and culture around the world. To commemorate Magna Carta and its powerful ideas, like trial by jury and due process of law embodied in its text, we have assembled an impressive group of scholars to discuss Magna Carta's influence on American constitutionalism. Tonight we will be joined by Jennifer Paxton, a medieval specialist from Catholic University of America, Robert Polito, author of In the Shadow of the Great Charter, who I heard gave a wonderful lecture this afternoon, and Bruce O'Brien, a Magna Carta expert from the University of Mary Washington. Tonight's program will be live tweeted on the ConSource Twitter page, live streamed on the National Archives YouTube page, and I'm told that C-SPAN is also here with us this evening. I hope folks joining us at home and around the world will tune in online and on social media. And with that, I now have the great privilege of welcoming to the stage our expert panelists, as well as our distinguished moderator, Judge Royce Lamberth, Senior United States District Judge for the District of Columbia. Please join me in welcoming them. And with that, I'm going to hand the reins over to our very capable, distinguished moderator, Judge Lamberth. Thank you.
Thank you very much, Julie. It's a pleasure to be here at the Archives. As you know, it was 800 years ago today that a group of English barons forced King John to sign a charter known as Magna Carta with the idea that the king's capacity to kill or imprison should not be exercised at his whim, but that he should have explicit constraints, that is, that he would be subject to law, and that neither force nor detention would be used against a free man except in accordance with the lawful judgment of his equals or by the law of the land. Those are the words from that 1215 version of the Magna Carta. You'll hear a lot tonight about the impact Magna Carta has had in this country, in both state constitutions and, of course, in the United States Constitution. Since England never adopted a constitution, in some ways the influence of Magna Carta is even greater in this country. Certainly the notions of due process of law and the right to jury trials have developed directly from Magna Carta, as well as separation of powers principles and judicial decision-making on what law is. Some of this is really fascinating historically, I hope you find tonight. For example, when the barons demanded a jury of their peers in Magna Carta, they certainly were not envisioning a jury of commoners. Their peers were clearly other barons. So some of their notions would be a surprise to them if they were here 800 years later and know how we interpret a jury of your peers to include mere commoners. But Magna Carta has become a rallying cry for centuries now regarding what the law of the land requires. And as we debate today current topics like whether the president can legally authorize drone strikes to kill American citizens. We hear citations to Magna Carta even today in legal debates about the power of our president. As many of you know, there was a great ceremony today at Runnymede to celebrate this 800th anniversary. Queen Elizabeth was there, along with the archivist David Ferriero, who is there instead of here, I'm sorry to say, but not sorry for him. I'm sure he had a great time. And many of my colleagues, the president of the American Bar Association, many of my other colleagues from the American Bar Association were there as well. I have to tell you one story about Runnymede, because when I was a student in law school, my last summer before I graduated from law school, I spent in Europe, traveling through Europe, and I decided when I was in England that I would go to Runnymede to see where the Magna Carta had been signed, the original version in 1215. The American Bar Association actually put up the memorial that is there. It was only put up in 1957, so the actual memorial with the plaque was erected in 1957. I hate to admit, but I was there in 1966 while I was still in law school. There was no pathway just in the middle of this field out at Runnymede, so I had hitchhiked up there. I had a Euro pass for traveling in Europe, but it wasn't good in England, so I had to hitchhike during the time I was in England, and I hitchhiked out to Runnymede, and I rode various rides to get up there, and I had my suitcase with me because I was going to Stratford-on-Avon to see Shakespeare's production and to go to the Globe Theater after I left Runnymede. So I traipsed out there in the middle of this field and saw Runnymede and was somewhat dumbfounded there wasn't more of a production to this whole scene, and it was just in the middle of a field, this small memorial, and I trekked back, and as I'm getting back to go back to the highway, I start sliding down this hill. It was pouring down buckets of rain, sort of like when you came in tonight, only buckets of rain, and I slid down this hill. My suitcase came loose and slid down behind me and then on top of me. So I was really one muddy mess by the time I got to the highway. No one would stop and pick up this muddy mess. Eventually a lorry stopped, and I was able to get in this lorry and get my way back to Stratford-on-Avon. So I have a very vivid memory of Runnymede. So I'm really delighted to be able to participate in this program tonight. The New York Times headline yesterday read, "Magna Carta still posing a challenge at 800. In typical New York Times fashion, there's also an opinion piece yesterday entitled "Stop Revering Magna Carta" by a law professor from the University of Chicago, naturally. He decries some of the myths that have developed about Magna Carta. We will deal with some of those myths during our program tonight, but the National Archives is a very special place to have a discussion about Magna Carta because, as you just heard, the 1297 version of Magna Carta is on display here. I was in this very room the night that David Rubenstein was honored by the National Archives for obtaining, through an auction in New York, the only copy we have in America of the Magna Carta, and for presenting it to the archives so it could be on display. And the archivist, David Ferriero, introduced me to Mr. Rubenstein that night, and it was one of my great thrills in life to meet one of our real American heroes who's really doing something with the $1 billion he made to improve our life of all of us in this country, and certainly preserving the Magna Carta as one of our charters of freedom is something great he's done for this country, I think. So I think I want to stop talking myself and get to our illustrious panel, and I will start as we do chronologically with asking Bruce and Jenny if they will give us, we'll start with Bruce, sort of a historical overview of the run-up to what happened in 1215, and then Jenny will talk more about the actual sealing of the Magna Carta itself in 1215. But Bruce, you want to start?
Well, thank you very much. As I was listening to your anecdote, Judge Lamberth, it struck me that your experience and King John's were not so dissimilar. So you could take some pleasure in that, that you have some empathy for that side. I am, as Julie said, a professor down at Mary Washington, but I'm also the academic lead and chair of the Literary Board of Early English Laws, which is a British state-funded project to publish, re-edit, and translate all early English law up to Magna Carta, including Magna Carta. And the reason I say that is because I think oftentimes people think here, and I don't blame them for it, that Magna Carta just springs from nowhere. Suddenly there's this medieval document that appears, and it's very important, and there's not a lot of attention given to what came before, and also not a lot of attention given to what came after until it gets to the colonies, and then it does take on a very vibrant and different kind of life. But the texts that we do in the project, there are 150 of them, are in fact all legal texts that predate Magna Carta. So there's a very vibrant legal culture going on in England up to Magna Carta, and Magna Carta, from that perspective, is just part of it. It's not something out of the blue. It's not something so surprising as a legal text, a text where people try to hash out what they think the law should be. And instead of taking you through all of the weeds of those texts, which are a lot of fun, they're all online, they're all free, instead I'll just talk about, I think, something that leads up to Magna Carta that's quite important, and that is the relationship of monarchs to the law. And because Magna Carta itself is, I think, probably at its core, a rejection of tyranny. It's a statement that kings do not have absolute power, that there are checks on royal authority when royal behavior is bad, that these should be invoked. That is an old tradition, not spelled out with quite the same detail as in Magna Carta, but an old tradition in English law. And I think if you wanted to trace when monarchs really started to felt compelled to put promises in writing to their subjects that they will administer the law correctly, they will administer the law fairly, they want their judges to administer the law fairly. You're looking at the 10th century, Edgar, who's king of the end of the 10th century, who is a powerful king, and he is nevertheless someone who makes concessions. And one of them is he begins this practice of promising in his law codes to honor them, honor the very laws, and to not be abusive, not be a bad king. And that practice is followed by subsequent kings. The Scandinavian king, the Viking king who conquered England in the 11th century, Canute, actually creates probably a coronation oath, an oath the kings would take, promising to respect the laws of the land. And in his case, what he was made to promise as part of the deal by which he got England was to honor the laws of Edgar. So again, it's this backward-looking precedent. These are the good old laws, I will honor them. And you can follow that, hopping and skipping all the way up to Magna Carta, even over the Norman conquest in 1066. A dynasty, to call it foreign is wrong because they're cousins. But William the Conqueror fights a battle, kills the king, Harold, and takes over the kingdom. It's always a mistake to have a very centralized government. When they fall very fast. And for hundreds of years, scholars have tried to sort out what happened. And one of the things I think that is interesting in terms of Magna Carta that happens is you see people taking a lot of pains to try to ensure that people feel comfortable that there's been a continuity of law and political power over the conquest, whether rightly or wrongly, whether that reflects reality. They create a concept of the laws of Edward the Confessor. And each king after, from William on, promises to honor those laws. And those are the laws of the last English king. Now, they don't exist. There was no code issued by Edward. But this notion that the Golden Age had produced laws that all English kings should honor is there. And so there again, kings putting themselves under the law, hearing the law from the people, and then putting themselves under it. And so one aspect of Magna Carta is that. It's just that you have a king, in this case John, who is put, though the document is from him, so he's sort of saying, I'm happy to do this, but put under the law, and with a lot of safeguards in place in that first Magna Carta. The only other thing I'll add, and this I'll revisit later when we talk, I think, about some of the common misunderstandings of Magna Carta, is that you should keep in mind, with all these legal texts, it's still very hard to know whether any of them is actually official as we would think of a law as official, something that people would go to as a source or reference. There's just a lot of law floating around. And when you look at what happens to Magna Carta afterwards, people start to adjust it, edit it, merge versions of it. It's really very strange. And so I think we tend to see it as this document that appears, it has these rights, and it comes out of nowhere and it has an influence. Well, there's a long lead up to it, and there is a different context for understanding it that should always sort of be there when we're trying to interpret what it actually meant to people of the time.
That's great. Jenny, you want to talk about how we actually did it?
Well, it's one thing for kings to promise when they're crowned to follow the law, and it's quite another thing for them to do it throughout their reign. And that's where effectively the rubber met the road with Magna Carta, because we come to a particular king, King John, and John is one of only 2 kings in English history never to have a successor named after him. So there's never been a John II, and I can confidently predict there never will be a John II. That name is definitely off the list. You know, think about when they name a new prince, you know, what are the names in contention? Not John. Now, there really are 2 proximate causes for Magna Carta. One is a foreign policy disaster, and the other is the character of the king. And I would argue that without those 2 factors, we would not have had Magna Carta. So the foreign policy disaster. Bruce mentioned the Norman Conquest. What the Norman Conquest did was to make England a cross-channel empire. So they've got England, and then they've got lands on the continent that they still control. And that's Normandy, where William the Conqueror came from. But over the course of the 12th century, they acquired basically the whole western seaboard of France. So they own basically half of France, which is great for the English, not so good for the French. So there is a standing conflict between the French kingdom and the kings of England. And it is exacerbated by the weird sort of feudal situation that obtains between them, because those lands in France that the English control, they are held of the French king as fiefs. So the French king is actually the overlord of the English king in his capacity as Duke of Normandy, Count of Anjou, etc., etc. Now, this is really a false position for 2 kings to be in regard to each other, because the sovereignties conflict. But they haven't sorted that out in the 12th and 13th centuries. And so it leads to a standing conflict of interest between them. There is fairly constant war between France and England in the French territories that the English control. They're always going back and forth across the border. And so now we come to the reign of John. John takes the throne in 1199 when Richard the Lionheart is killed in really a rather unimportant skirmish in the south of France in a territory that he controlled. You have John on the throne, and the King of France is immediately going to try to take advantage of the relative instability of the succession to seize some land. But they come to an agreement. Everything is going to be fine, and then John gets married, and that screws everything up. It's one of the most disastrous marriages in English history for a number of reasons, but one reason is because of who the bride is, and particularly because of where she comes from. This is Isabel of Angoulême. Angoulême is a small territory in southwestern France. The problem with Angoulême is that it adjoins the county of La Marche. And La Marche was ruled by a family that were constantly rebelling against King John. Now, John did not want the Count of La Marche to marry Isabel of Angoulême. They were engaged. So he wanted to block that marriage because he feared that if these 2 territories were united, then there would be this big indigestible block of rebel territory in the heart of his French dominions. So he doesn't want this marriage to go forward. So what is his solution? He marries the bride himself. He scoops in, takes the bride, marries her himself, and oh, by the way, they had been postponing this relationship, the Count of La Marche and Isabel, because the bride was 12 years old. But the king marries her anyway. Now, this might have been okay if the king had compensated the Count of La Marche for stealing his fiancée. But John was just the sort of guy not to do that. It would have been much better if he'd say, well, I'm sorry, I took your fiancée, but here is some extra land, here is a payment, it's all good. He didn't do that. He basically thumbed his nose at his own vassal, and that caused the Count of La Marche to appeal to the King of France. Because, of course, the King of France is the overlord of both the Count of La Marche and the King of England. So he appeals to the King of France, and the King of France has just been waiting for an opportunity to do something against King John. And here this is delivered to him on a silver platter. Because, of course, John has violated the rights of his vassal in taking the fiancée without compensation. And so the King of France confiscates the lands that the King of England owns in France. And then he actually makes good on the confiscation by force of arms. And he invades Normandy and he conquers it. Now, the King of England has lost all the land in France, or lots of it, okay? And particularly the land that people actually cared about, Normandy. And this is a complete disaster. Kings of France, or kings of any kingdom, are not supposed to lose land. If anything, you're supposed to increase it, not lose land. And now John is in a bind because he has to try to get the land back. He needs to pay for the reconquest. He can't pay for it because now all of a sudden he's not getting any revenue from that land anymore. So he has to tax England unmercifully in order to pay for the effort to get the land in France back. So he is now in a vicious circle because the more he taxes England, the more they hate him. Okay? But he has to get the land back or he will lose face as king. And it goes on like this for about 10 years. In 1214, he basically makes one last effort to recover the land in France. He gathers together a coalition of continental allies, in particular his nephew, who is a German nobleman. And he's going to do a pincer movement. So his allies are going to come into France from the northeast. And John is going to land in Poitou in the south on the coast. And then they're going to meet up, head towards Paris, and get the King of France sort of in a vice. But it doesn't work, okay, because John is bottled up on the coast. He can never meet his ally, so his ally has to go up against the King of France alone. And there is a battle between the King of France and this German ally, and the French win the battle. And the battle is called the Battle of Bouvines, and all commentators on Magna Carta will agree that there is pretty much a straight line from Bouvines to Runnymede, because the barons in England are basically waiting on the sidelines to see if John is successful. If he is, maybe they'll forgive him all the other stuff he's done. But if he's not, they're done with him. And this battle takes place in July of 1214. In the fall of 1214, the barons are already gathering together to talk about what to do about King John. And by the spring of that year, they are actively discussing some of the issues that end up in the draft of Magna Carta. So that's the foreign policy cause for Magna Carta. But there is also a character cause for Magna Carta, which is the fact that John was detested widely by his barons. He was regarded as untrustworthy, vicious, cruel. He was just the sort of person who you would have to extract promises from because he didn't keep his word. He was basically well known for that. He was somebody who acted arbitrarily. One of the things that he did to raise money for this continual effort to recover land in France was to fine people arbitrarily for offenses that sometimes were real and sometimes invented. He would lend money to people in unrealistic amounts and then have the debt hover over them. And so people were always scared of what John would do. He was very unpredictable and really just the best example, I think, of the kind of cruelty that John engaged in. He got into a dispute with one of his vassals named William de Brieux, and he actually had the wife and son of this vassal starved to death. Okay? And this was widely known. All the chroniclers of the time report it. Okay? It was widely known. So that was the kind of thing he did. And he also would go around to the castles of his barons and demand to sleep with their wives and daughters. This is the kind of man he was. So this is the kind of person who you would definitely want to promise on parchment that he was going to be a good boy.
Now, Bruce, you mentioned before, it's sort of anomalous that this became such an iconic document in the United States, and I guess part of it, maybe you can also talk about the reinterpretation by Edward Coke and the impact of the English Bill of Rights in this country then. But
Sure. It's actually an interesting tale, and it's pretty straightforward. At one point, strangely, I ended up teaching the American Revolution in graduate school at Yale. Ed Morgan was there, and they were desperate. The Americanists were all off doing work, so he said he'd take anyone who could stand and read, and I could do both. But I had to bone up on American history because it had been a few years. And what I realized in doing that was there was this interesting connection between Magna Carta through the Petition of Right to the Bill of Rights, to the colonial petitions, to the Constitution. And that's actually, I started my students that semester with Magna Carta. They were a little puzzled that that was their first reading. And the reason we see the link is textual. Each of those sources is citing the earlier source. But what happens to it in the 17th century is pretty remarkable. This is England coming out of the Tudor period, which is exactly like the TV show, The Tudors. Oppressive, violent, driven by personal motive. And the Tudors were monarchs who believed in their own power. They thought that they were, in fact, quite the best thing around. And they weren't going to be troubled by the niceties of parliamentary precedents that had been built up over many decades. And they're powerful kings, so they did what they wanted. And Elizabeth is not that much different from her father, Henry. So England in the 1500s is a period where you have a lot of smoldering resentment amongst people who operate in the law, people who operate in the state, not just religious dissenters or Catholics, but these folks. And they began to consider, what they could do. And a lot of them gathered in London. They were associated with the Society of Antiquaries. Sounds very tame, kind of a thing to go, a sleepy place to retire to after your active life. But it actually was a hotbed of revolutionary zeal. And the members there would read old documents. They would read old laws coming back from the Anglo-Saxon period and all the way on through Magna Carta and then laws that have been passed since to try and figure out what their strategy should be. One of them, Edward Coke, ends up as Chief Justice. And he rules in a number of cases in such a way in the 1606 to 1616, somewhere around that's when he serves, in such a way as to reinterpret Magna Carta. Magna Carta is a very narrow partisan document. The people who draw it up benefit from it. The same kind of argument was made about the American Constitution by Charles Beard many years ago. It's partly true and partly not. The barons were very interested in themselves, and so when they talked about people, they were really thinking of well-to-do people. They were thinking of free people, not the unfree. They were thinking of men, not women. That's kind of where they were. And Coke, in changed circumstances and a changed notion of what justice was, rethought it and said, we're going to extend this as a precedent to all men, to all people, not just to, in fact, this very narrow clique. And so in a number of rulings during that period, he did so. That led to, part of that was the Petition of Right, which followed, which was asking the king of the time to, in fact, honor a number of the basic items in Magna Carta that show up there. Those later get expanded on in 1688-89 during the Glorious Revolution to the Bill of Rights, the English Bill of Rights. You know, you can't quarter troops, you know, due process rules. It's all kind of there, all of the legal principles burnt out. And that's what the Americans get, because that's when they're settling. That's when they're coming over and colonizing. They have libraries, they have books, they have Cook's commentaries, they read them, they apprentice at law in the same way that it's a similar kind of way that they do in England. And so they're keenly aware of that tradition. That is their heritage, and it's in their charters. And so, I mean, there's this, it's all one culture at that point. And Cook is huge for giving them a new way of thinking about Magna Carta.
That's exactly what I was looking for. Rob, why don't you talk a little about, let's start with Magna Carta's influence on the colonial charters, because that's where it really started here. And go from there to the pre-revolutionary period, I guess. But
okay, so the language of the Magna Carta was reproduced in a number of the colonial charters. In at least one colony, the colonial governor reviewed legislation to make sure that it comported with Magna Carta. In the sort of the discourse, as far as we know of the time, people talked about claiming the same rights that Englishmen had. After the Revolution, they wouldn't speak in those terms, but before the Revolution, they did. So all of that was happening before we had the series of documents that we talk about as our founding documents, the Declaration of Independence, the Articles of Confederation, the Constitution, and including the Bill of Rights portion. So in the Declaration of Independence, I mean, there's an obvious similarity because they're listing a series, or they're creating a series of complaints about the king, and in this case, justifying why they're separating from the king. So the war is just starting. In the Declaration of Independence, there are some statements that refer to not only the Magna Carta, but the lineage of the Magna Carta. For example, when it says that the king has created a jurisdiction foreign to our Constitution, the writers are talking about how the principle of the authority being subject to law was not being followed. And of course, our Constitution didn't mean a specific document. It meant all of the principles and customs that English law followed. So that's the Declaration of Independence. In the Constitution itself, there are several references that also connect to the Magna Carta. The first one is in Article 1, listing out the powers of the national legislature, where it says that the privilege of habeas corpus will not be suspended except by Congress and except in very limited circumstances. I should explain just really briefly that habeas corpus is a form of pleading in which you request to be brought before a court so that you can show that you're unjustly confined by the state. So that's why a lot of people talk about habeas corpus as sort of the most basic right as against the government, because it allows you, no matter what the circumstances of your confinement, to come in and say this fact of confinement is unlawful and I must be released. So you go back to Article 39 that Judge Lamberth mentioned earlier, that says that no one will be taken, the king will not go against anyone except by law of the land. And so the law of the land meant that if the confinement was unjust, then you ought to be able to appeal it. You ought to be able to seek relief from it. And this was true whether you were simply captured by the government, whether you had been tried and convicted and had exhausted all of your appeals so that appeals were no longer possible, whether you were captured and not charged with anything. And I'm jumping ahead a little bit, but that's the situation of the Guantanamo detainees today. And when we talk about the legacy of the Magna Carta in our time, I'll say more about that. But so habeas corpus is a form of pleading, and it is the procedure that allows many state detainees to go free, both in England in earlier times and right through to today. So in Article 1 of the U.S. Constitution, there is this provision that states the importance of habeas corpus, which connects to Magna Carta, as I've said, and says that it can't be suspended except in very limited circumstances. Then there are the provisions granting a speedy trial, trial by jury, and due process. All of those are reproduced in the Bill of Rights, part of the Constitution. So there are 2 due process clauses in the U.S. Constitution, both the 5th and the 14th Amendment. So the 5th was adopted as part of the original Bill of Rights, the 14th Amendment after the Civil War. Both refer to due process, and again, we'll say more about this later, but due process is another way of saying law of the land. Incidentally, if you want to talk about how the Magna Carta continues to influence law today, and I literally mean today, Julie told me earlier that the Supreme Court ruled this morning on a case called Kerry v. Dinn, and that they cite the Magna Carta for this very principle, that due process means law of the land. So the Due Process Clause has a direct textual connection to the Magna Carta. And then, of course, there's the right to jury trial, because Article 39 and 40 say that you can't be imprisoned or punished except by lawful judgment of your peers or by law of the land, and that to no one will be delay or deny justice. So each of these refers to trial by jury, respectively, and the right to a speedy trial as well. So these are provisions in the Bill of Rights. So you see that in the Constitution itself, we've enacted language that operationalizes these guarantees that are set forth in the Magna Carta, and they become directly part of our law. And of course, since we do have a written constitution, unlike Britain, right, so lawyers will cite to these provisions and even use these rights as a source of an action many times in court.
And Bruce, I take it that a number of state constitutions enacted at that time did the same, relied on language from the Magna Carta and the English Bill of Rights.
It's certainly in a lot of the colonial statutes and charters. It's in a lot of the charters, and is something that through the 1600s is well known to all throughout the colonies, Georgia all the way up to New Hampshire. So yeah, this is something that is, again, I don't think it's all that different initially than what someone in England might have felt. But it's the increasing alienation of the colonies that gives it more freight, because they start going back to these, because those are the things that are challenged by the English monarchs. And they say, well, hold on, what is our charter? And it starts to actually take on a new life for them.
Good. You also, Bruce, were talking about the myth of the Magna Carta. Let's talk a little more about what the myth is.
Well, a couple things to say here. One, myth is not a bad word, right? Myth is, I was reading the op-eds today, partly out of vanity. I got to do an op-ed for the first time. You know, no one asks medievalists to do op-eds. So this is it. This was it, you know. I was seeing there's a lot of very similar kinds of things, but people were talking about the myth, and I don't think I used myth, and as if it were a bad thing, that I'm going to expose this document as something like a fairy tale. Well, myth actually isn't that. It's a powerful story in some way. It's something that maybe takes on power outside of its mere words. You know, you could say the Bible has mythic qualities to it. You know, this is fine. So when I use myth, I'm meaning it in that sense. I think we tend to, as Americans, miss some things about Magna Carta that are kind of, they're in the footnotes, so to speak. But they're the kind of interesting things that I think make it come to life. And these, instead of demythologizing it, I think you just keep these things in mind and say, well, this is a human product. Human society is complex, and what it produces is a reflection of that. Well, Magna Carta is a statement of principles, about due process. Robert was talking about due process, the key one, Chapter 39. But it also includes several chapters. Chapter is just, might be 20 words that describe something, that draw their text from a early 12th century forgery by Geoffrey of Monmouth, which is about the kings of Britain and Arthur. And this is what people are reading, and they're reading it in Latin, they're reading it in translation. It's available in French at the time, and somehow words make it into the final document. So that's kind of interesting. And then the second is that a number of the key principles about the king being just are first found not in the various drafts and documents of the barons. We can actually track their process of writing Magna Carta. It's really fantastic. You can't do that with many documents. But the earliest document where we see that stuff taking form is something called the Laws of the English, the Leges Anglorum. It is a forgery. It claims to be the laws of Edward the Confessor, which it is not. And someone has put in, Arthur, who is a great legislator and conqueror, has put in all these maxims about how kings ought to be just and ought to rule by right, and a king who does not rule by right is no king at all, and so on. But it's a forgery that they're including it into. I don't know if they know it isn't a law code per se. So that's kind of interesting. The most radical parts of the Magna Carta get cut out. So we get the stuff that, through the tests of time, which means politics, the things that survive through politics, like due process and jury trial, we get those now. But at the time, Magna Carta had a clause for enforcement that was quite revolutionary. The barons would form a council, and when the king misbehaved, they would basically appoint a posse to go after him and rustle his cattle. Or that's the process called distraint. We're going to take a lot of your property until you behave, John. And so they have that all worked out. And John agrees to that. Now, that gets cut out immediately. War starts. But, I mean, that's a remarkable thing. I mean, it's pretty remarkable what survives, but that's even more remarkable. And then the last thing I alluded to earlier, we tend to think, because we're a very text-oriented constitutional culture, as Robert has mentioned, the British don't have a constitution, and it works out okay over there. They've done all right over the centuries. But we think it's very important to have everything in writing. And so we think of writing as here are the words. Here is what the king and the barons agreed. These are what was said. Well, if you look at what happened to Magna Carta after it was issued, so 1215, they agree to it, gets sealed. Copies are ordered to be sent out. Then they're immediately annulled by the Pope, who basically considers John a vassal. 1216, it gets reissued as a way to end the Civil War. 1217, and then 1225 is the big one, and then there's the one in the 30s, and there's one in the 50s maybe. It gets reissued a bunch of times with different chapters. And that's confusing enough, because there is no point where someone says, well, hold on, that's the old edition. You can't cite that in court. Creative scribes began to combine them, taking the parts they liked and dumping the parts they didn't. So anyone walking into a library and say 1230 and saying, well, I've heard about Magna Carta in Rome. I came all the way to see what a fantastic, well, they say which version? We have like 30 or 40 different versions of it. And they didn't sort out which king had signed it for 500 years. They thought it was Henry III, not John. And so again, it's in Cook's day, or actually after Cook. It's in the 1700s that they sort that out. So it's a document, but not kind of like our Constitution in that sense.
You had some skepticism, Jenny, about whether it's worked better in England or here.
Oh, I don't know if this is the occasion for that when we're all talking about Anglo-American friendship today. So.
Rob, you want to talk about the myth?
Sure. I mean, as Bruce was saying, there are a lot of different dimensions to myth and a lot of different ways of understanding what a myth is. But in one specific sense, people have written, Edward Jenks in 1904 wrote an article basically saying that this was not a document that spoke for the common people. This was not an origin of cherished rights. It was simply an agreement between one wealthy person and a group of other wealthy people. And I mean, it's pretty clear that you can't disagree with that on those specific terms. But like the U.S. Constitution, we have a constitutional culture that incorporates a number of myths, including the myth that we were born a free nation, right? There were some people who were very much unfree when the nation was born. So I guess my take on the question of the myth is that it's undoubtedly correct to say that there are a number of mythic things about the Constitution, but that for...
Sort of like the myth that all men are created equal.
Right.
Did not include
exactly right, Judge Lamberth. So yeah, but at the same time, we can utilize that myth, and it can still shape our law. and we can move toward a position in law that's actually closer to what the myth was stating.
I had another question I wanted to ask all the panelists, and that is, what do you think is the continuing influence of Magna Carta today? And we'll talk about some specific things, for example, executive action. Rob, you want to talk about that one first?
Yes. So first of all, I mean, there are some real concrete, specific questions today about executive action that force us to ask, really, what is the executive subject to law, which is the basic thrust of Article 39, right, that the authority is subject to law. You can take the example of drone strikes, for example. This is a due process question in the sense that something's being taken away from people, namely their lives, without a hearing, without any kind of judicial ruling, but simply as a result of internal deliberations within the executive branch. So the Obama administration has explained that to them, due process doesn't always mean judicial process. In other words, due process is a flexible concept. Any lawyer will tell you that, but that in fact it's so flexible that it can be stretched to say that you can deprive someone of their life without going to a court. The deliberations that suffice to be due process can take place completely outside of a court and without any judicial official being involved. And this is something I think we need to talk very seriously about, because what does due process mean if the executive can take life without a trial? I mean, that sort of directly contradicts what Article 39 says.
The barons certainly didn't think that's what they were doing with King John, did they?
I think they would have had a problem with that, yes. And then there's something that some legal theorists talk about, which is a state of emergency or state of exception. So back in the earlier 20th century, Carl Schmitt came up with this theory of a state of exception and basically said that there was always a space beyond law in which the executive had to operate at certain times. And so the executive was normally bound by the restrictions of the Constitution in a constitutional republic, but that sometimes that state of things had to be suspended, and we moved into this other space beyond rules, beyond constraint for the executive. Obviously, this is a fundamental problem of legal theory, because once you say the executive is not bound by law, not only are you going against this core principle of the Magna Carta, but you're also in a sort of, there are no limits, essentially. Some legal scholars have struggled with this idea, trying to come up with a model of what would an emergency constitution look like. Bruce Ackerman has said that we could have an emergency constitution that kicks in at a certain point, and then it would suspend certain kinds of limits on executive power, and then for it to continue, it would have this is quite a mouthful, but a supermajoritarian escalator, which is, classic academic jargon, but it's not a thing in a shopping mall. It's actually a principle that says the longer the state of exception goes on, the larger the supermajority that has to approve it. So scholars have grappled with this idea, and particularly after September 11th, if there's going to be a state of exception, an emergency constitution, what triggers it, how long does it last, what rules apply? And it's one of these tantalizing problems, because once you admit that there are no limits, how do you put limits back in? So that's the sort of one of the conundra of executive authority in our time, looking back to this basic principle of authority is subject to law.
That's an excellent answer. I appreciate that. Jenny, talk about jury trial and how Magna Carta is, obviously, from my opening comments,
Well,
I think it's had a great influence in this country.
It actually belongs sort of in the category of the myths of Magna Carta, because the word jury does not appear anywhere in Magna Carta. So the idea that Clause 39 of Magna Carta guarantees the right to a trial by jury is actually a much later interpretation of Magna Carta. That's not what anybody thought in 1215. It's a really interesting example of how two phenomena can coincide in time and then over a period of time actually coalesce. So what you have is Magna Carta being agreed to in 1215, and that very year you have a huge event in the Catholic Church called the Fourth Lateran Council, where Pope Innocent III, who annulled Magna Carta, gathered together a huge assembly of bishops and other church leaders and hashed out a number of very important issues before the church at the time. And one of the things that they did was to ban clerical participation in the judicial ordeal. Now, probably a lot of you have heard of the ordeal. This is where people are forced to walk across hot coals or hold hot irons or be thrown in the water, and if the water accepts them, if they sink, then they're innocent. If the water rejects them and they float, then they're guilty. Now, of course, you have to fish them out in time if they're innocent before they drown. This is something that people make fun of now. I mean, there's a wonderful scene in Monty Python and the Holy Grail about the judicial ordeal. But this was very serious business in 1215. A lot of decisions about guilt or innocence across Europe were made on this basis. And the church had grown uncomfortable with it and withdrew its approval. And this almost immediately caused the ordeal to wither on the vine. And they needed something else to put in place in order to decide guilt or innocence in criminal cases. Now, interestingly, on the continent, what they came up with was the inquisitorial process. Okay. In England, they went in a different direction. By the way, that involves torture. Right? In England, they never embraced torture. Instead, what they came up with as a fix was the jury trial. So juries had been around for other purposes for many years. They were fact-finding bodies. They had been used by William the Conqueror, for example, after the conquest, to try to figure out what did he have in the Doomsday Inquest, where he went around and found out what all the land was and how much it was worth. That was run on the system of local juries. So juries get co-opted to take the place of the judicial ordeal. And over time, people start to assume that the clause about judgment by your peers refers to trial by jury. Okay. But that's not, in fact, how it was interpreted in 1215, because there was no right to a jury trial. There were no jury trials in 1215. So that's one of the signal myths of Magna Carta. By the 14th century, people are making that connection, and by the 17th century, with Cook and other commentators, people are flat out saying that Magna Carta guarantees the right to a trial by jury.
And from the beginning of our country, then, we really did believe
Absolutely.
in trial by jury.
Absolutely believed that that was a guaranteed right as of Magna Carta. It's not in there.
And what about speedy trial?
Well, Clause 40 of Magna Carta says that to no one will we deny or delay justice. So this is the idea that you have to get your judgment in a reasonably speedy fashion. And it is an outgrowth of the sort of things that John would do, which is to imprison people sometimes for years without judgment. And he would do this basically to extort more and more money out of the person concerned and out of their family. So one of the really interesting things that you can do in reading Magna Carta is to see what King John was actually doing by what he was being told not to do. Okay? And this, the speedy trial is definitely
That was certainly one
of
them,
those.
Right. Rob, talk a little more about habeas corpus, because that's really, in this country, has turned out to be extremely important, certainly from Guantanamo point of view, but other points of view in this country. Habeas is the key to the judiciary deciding a lot of things in this country.
Yes, we can go through U.S. history and find conflicts where habeas corpus figured very prominently. During the years preceding the Civil War, habeas corpus was used both to return slaves to their captors and sometimes for slaves to be freed and sometimes for slave catchers to be freed. In Prigg v. Pennsylvania, actually the slave catcher was prosecuted under a law prohibiting kidnapping, and then he sought relief through habeas corpus, saying my prosecution, my confinement are fundamentally unjust, because Pennsylvania did not have the authority to pass this law. It interferes with fugitive slave enforcement in the Constitution. So habeas corpus is this very powerful tool, but like any other tool, it can be used for different ends. And then when we jump ahead to the Warren Court in the 1950s, the Warren Court broadens access to habeas corpus as part of a more general project of increasing access to the judicial system, political process, striking down, as everyone knows, state-enforced racial segregation. In one particular case, Justice Brennan refers directly to the Magna Carta and how it has been functioning differently in our system with a written constitution than it did in the British system, that in both systems, habeas corpus would be a sort of a key component of protecting liberty that came from the Magna Carta. Some historians say Justice Brennan got the history wrong. Maybe he did. But the point is that frequently when habeas corpus is being interpreted, applied, discussed, there is this connection to the Magna Carta being made. Then in the Rehnquist years, the court restricted access to habeas corpus in some ways. There's a very well-known case, Herrera v. Collins, where a prisoner was scheduled to be executed and claimed that he could prove that he was innocent. So he sought to make a showing in court via habeas corpus that he was innocent. He was denied that opportunity. He was executed. The dissent was very angry in the case. Justice Scalia actually said that actual innocence in our law is not a reason that entitles you to habeas corpus. In other words, Scalia was saying if the trial was fair and you're not complaining about the trial, you're not entitled to a habeas corpus hearing because you've discovered evidence later on. I mean, that's a very controversial statement, but it shows how habeas corpus has been contested, how there's been somewhat of a pendular movement between broadening and then constricting. And then finally, scholars have noted a similarity between the way habeas corpus was manipulated by English kings and the way the Bush administration manipulated it in this specific way by moving a prisoner out of the realm, so to speak, right? The writ of habeas corpus wouldn't reach to them. And so we're talking about taking someone, at least until the Supreme Court said that the Constitution reached Guantanamo Bay, that was a strategy that could be effective. So habeas corpus is not available if you're not in the realm, just as it was not when the English kings moved prisoners out of the realm. And then this brings us up to the 2008 case of Boumediene v. Bush, which is kind of what got me interested in looking at these Magna Carta U.S. Constitution connections in the first place. So Boumediene was a case where Guantanamo Bay detainees were requesting the right to make a habeas corpus petition and had been denied. And in that case, Justice Kennedy cited the Magna Carta directly, said the Magna Carta via habeas corpus was this very important mechanism by which people could protest their unlawful confinement by the government. So there is a real practical legal effect to the continued citation of the Magna Carta, because it's a way of putting a check on the executive, and it happens in 2008. One of the other things, if you read the oral arguments in not only Boumediene but the other detainee cases that were decided a couple of years earlier, is that you see there's a question about habeas corpus and exactly how it's used. So when you make a petition, right, so the return is a hearing at a later date when the government comes in and shows their reasons why they've detained the prisoner. Well, what happens if the government says, we've detained the prisoner pursuant to our executive authority. We've detained the prisoner for treason. We've detained the prisoner because the prisoner is a threat to the security of the country. Is that enough? Is that showing enough? Or is there something more that has to be done? Or can then the prisoner respond? So as important a tool as habeas corpus is to protect and secure and sometimes gain liberty, it is also very important to know exactly how it functions. And that was something that was contested by some of the administration lawyers as they talked about how the habeas corpus petition should proceed. And then, of course, after Boumediene was decided in 2008, there were a large number of hearings because just getting the right to make a showing that you should be freed doesn't mean that you're going to be freed. And in fact, most of the petitioners weren't. But the years following 2008, up until recently, there was litigation where petitions were made, petitions were denied, the denial was appealed, and so forth. So that's not a particularly happy story in terms of liberty because most of the petitions were unsuccessful. But again, it does show that we're still talking about and trying to come to terms with this tool of protecting individual rights now.
All right, that's a good segue to our final segment of the panel. We do want to take questions from the audience, and we'll be happy to answer questions. The panelists will. I may not. I will if you ask. But first, I would like to say thank you for a terrific discussion for the panelists. Please join me in thanking all of the panelists. For the questions, if you will come down to one of the microphones, or someone will hand you a microphone, well, I would appreciate it, so we can make sure that our audience who's not here in the auditorium also hears the question. And you can direct it to a panelist or to the panel in general, whatever you prefer. You can start.
Was the position of the Church of England affected in any way by Magna Carta?
Yes, the first clause of Magna Carta guarantees the liberty of the church. And it actually grew out of a huge controversy earlier in John's reign. John had refused to accept a candidate for the Archbishopric of Canterbury, and this had ended up before the Pope to resolve, and the Pope had imposed his own candidate, Stephen Langton, as Archbishop, and John would not allow this Archbishop into the kingdom. This was probably, on the whole, a bad move on John's part because the Archbishop of Canterbury was ultimately accepted after an interdict, 7 years when the church went on strike in England and no masses could be said, and finally John had to cave, and he actually surrendered the kingdom to the hands of the Pope as a fief. But Stephen Langton, that Archbishop, he eventually had to accept him. And Stephen Langton was right there at Runnymede, and he was probably the author of the first clause of Magna Carta that insisted on the liberty of the church, and what that meant was hands off of elections to bishoprics. So it was, in a sense, it was a very self-interested clause from the Archbishop of Canterbury's point of view, but that clause is still in force in England today. There are only 3.5 clauses of Magna Carta that are still on the books in England. All the others have been repealed, but the liberty of the church is still part of English law to this day.
And an important part of our Bill of Rights as well.
Can I just add as an appendix?
Sure.
You know, that the issue, that confrontation of church and state was something that there had been a lot of practice with. Going back many centuries, the earliest English law code we have from around the year 600 has protection of the clergy in there and trying to sort out what their relationship is to the state. But in the 12th century alone, leading up to Magna Carta, there were archbishops who went into exile, most famously Becket, who was then murdered by enthusiastic knights. And that was also a moment that prompted a lot of soul searching about English law, because that's when we have the bulk of our 12th century manuscripts of law produced. And I think it's just in response to Henry saying, I know what the laws are, and Becket saying, I know what the laws are. People start to look. And so they're trying to figure out what the liberty of the church is, how much freedom should it have, and how do you get a king who is otherwise out hunting, you know, to actually honor these promises.
My question over here.
The title of this panel is Magna Carta and the Constitution, but most countries have constitutions. Can you talk a little bit about the effect of Magna Carta on the constitutions of other countries?
I couldn't. Maybe the panelists can.
Well, one thing that's actually quite interesting is the impact of Magna Carta via the English Bill of Rights on the European Constitution. And there's a tremendous irony at the heart of this, because a lot of these English rights inspired the creators of the European Union. And of course, what's happening in Britain right now, they're actively talking about withdrawing from the European Union. And one of the things that they're concerned about right now is the Human Rights Act in Britain, which is a provision that regulates appeals to the European Human Rights Court. And they're trying to repeal it and institute a new provision that puts everything on a basis that stays in Britain so that they have no connection to what's going on the continent. So there's a tension here where you've got the British who inspired the Europeans trying to get out of the European construct altogether. So Magna Carta has had some interesting effects around the world.
Your question does raise one other thing in my mind, and that is the controversy in our own Supreme Court about whether they should ever cite foreign law. But apparently Magna Carta is not considered foreign law, since they cited it today. Question over here.
Well, just to comment just quickly on the irony, I mean, to me, I mentioned it to the speaker this afternoon, you know, that you have to essentially be strip searched to come to view these documents that
Right.
actually are supposed to be about our freedom is rather ironic to me. But regarding the build-up to...
I think that's a terrific comment, but
Well-
it is society today.
Well, and I was actually talking with the speaker this afternoon about just the working hypothesis that I've come to, having had everything that I've owned taken from me over the last 4 years by police or state or county enforcing laws that either didn't exist or were not based on data. But the question or comment I have is regarding the lands that were taken in coastal France. And then you were commenting about the money that was coming to England from those lands. And I'm, you know, always thinking about resources. So was that a fishery issue, in that the fisheries that, you know, were very productive in the coast of France, was that the money that was actually supplying John or England with resources to do what they were doing?
Not primarily.
No, okay.
I mean, these were actual tax revenues that were coming into the treasuries in these different French domains. So there was a treasury in Normandy, there was a treasury in Anjou, and that money was now going to the treasury in Paris
But-
instead of to England.
Well, I guess my question, though, is the taxes were being levied on what production of goods? Was it coming from, you know, I guess farmlands as well as coastal fisheries?
Mostly
And-
land,
and-
mostly
okay.
land and other kinds of trade.
And I'm coming at this because while I was defending myself to North Carolina Superior Court because I was building an oyster reef for free using my kayak in 2013, I was reading a book called The Mortal Sea, and it was a history of the North Atlantic fisheries, and it was actually starting in 900 AD because the author was making the point that by that time, the onshore fisheries in the Middle East, North Africa, and Europe had been depleted due to human innovation, and that was actually when coastal fisheries were actually starting to develop. And so he's tracking this development of the progression of the depletion of the fisheries, starting in the eastern Atlantic, moving to the North Atlantic, and then progressing into the western Atlantic. And it's
There's a
interesting.
question
he
there
notes,
somewhere, right?
yeah, well, I'm sorry.
Okay.
Well, he's just noting that in this, when the fisheries were depleted to the point where the western Atlantic was being affected, the interesting thing in the colonies was there were laws that were basically regulating the fisheries. The irony was those laws were passed by the biggest profiters of the fisheries, and therefore the fisheries continued to decline. And he notes that by the 1800s, the King of England then commissioned a study of the scientific community in England to figure out what they could do. They looked at their research, they came back to the king, and they said, you know, there's nothing we can do. The people fishing have to regulate themselves. And he notes that the King of England at that time put his stamp of approval on that. And so it was ironic to me. I'm reading this while I'm defending myself to North Carolina Superior Court on charges against me because I was building an oyster reef for free using my kayak, which those charges were ultimately dropped because the state had no data to support closing all these waters. It's just ironic that we live in a culture that's so wealthy. More and more what I'm seeing is, like the Magna Carta, the laws typically are the result of people being sedentary because of their wealth, and therefore there's actually cognitive consequences due to being sitting that creates a lot of fear. And that's something that's at play, I think, especially with 9/11 and these drone strikes and more, especially with our country. Just
Okay,
thoughts.
we got the point. Let me go to the question over here. Go ahead.
Hi, my question is about the signers of the Magna Carta and the number of them and whether that number changes. Are there more Baron families added? Do the sons of, as Barons die off, do the sons sign off on these different versions of the Magna Carta? I'm trying to do I haven't really found the direct link, genealogy link yet, but there seems to be, I'm tracing a family right now in particular, and so I have a question around the signers.
Well, I think the farther back you go, the better your chances are of being connected to people who matter. It's pretty easy, I think, for most Americans to somehow hook up into the lower nobility by the 1400s and then to potentially be descendants of one of these barons. There's an organization, of the Barons and Dames of Magna Carta, I think is what it's called. It's an international organization. Oh. And you might want to consult with them because they see it as their task to keep tabs and to verify who is connected. And each time Magna Carta gets reconfirmed, you have new signatories. So in 1225, when it comes out, and that's the official version, that's the one that's trimmed down, the king's okay with it, and it's the one that gets trotted out every time. Only 3 of the barons who had originally signed 1215 are alive to sign, and they're, I think, sons of 3 others, and that's it. So, but it's a whole new batch. But I don't know if they count. You'd have to actually talk to the organization. I think it's just 1215 is all they care about. Maybe there should be like separate organizations for each engrossment. They could have a big jamboree every summer.
That's a great answer. Yes, sir.
I was at the Jefferson Memorial the other day and reading one of those tableaus, quotes from Jefferson in the memorial, and I'll make a hash of it, but be brief, that in a letter to a Virginian, he said that laws that do not change would be the same as a man putting on a coat that he wore as a boy. And being also a liberal arts student and knowing that Wikipedia is the authority on all things, I wanted to ask the notion of the strict constructionists or which used to be called originalists, according to Wikipedia, that how could you not see the Magna Carta seemed from listening to you like a negotiating document as a basis, as you said, Judge, about what you could tell by what it was in there, what King John was doing. So that's where I'm a little confused about how you could have such a wide gulf between this idea of negotiation that changes versus these are words that are iron-bound and, and I can tell what somebody 200 years ago had in their head. You can tell my position. But I did enjoy your comments on that.
Can I leap into that? I'm a historian, I'm not a lawyer, and this actually taps the great divide between how we see things. Historians look at these laws from the past and we say these are artifacts. And they worked in their culture in different ways. And historians look at Magna Carta and they see a whole series of documents there were negotiations, there were interpretations, misinterpretations, reinterpretations, all kinds of strange things going on perfectly fine in history. The moment you say, but this needs to be the foundation for things we do in the present, and the present is a moving target, that's when you run into problems. But that's essentially what law does. And it works in a system of precedent. So, if you talk to an audience of historians, they'd all nod and say, absolutely. we're on your team. Talk to lawyers, and they say, well, they're, even if they're not strict constructionists, they say, well, you do have some problems, because how then can law provide the stability and predictability that is part of due process, which is one of these great things that we have in our system. And so they don't see the historical way out of that. And historians don't actually know how to advise lawyers either on how to take this into account. I'm as a legal historian, I go to conferences, and they're evenly divided. They're the lawyers, the historians, and we all talk to one another, and nobody really understands one another. So, I mean, and the matter of originalism, I mean, the op-ed I wrote for today was taking a shot at that, but it's a standard historical shot that basically Cook reinterprets it. That's a good thing. He reuses the words in different ways, and none of us should be unhappy with that. And that's simply how language operates. But I do think that what the labels that you're talking about are inventions of the present. It's just ways we have of sorting out something that's inherently messy and doesn't work. I mean, that's the great message of Magna Carta at 800 is, so what are you going to show me for the next 800? Because there's a lot of work left undone, and the judicial system, especially in criminal law, is as imperfect as it ever was. I don't see a great advance, but I'm looking at it for several thousand years.
But as the historian says, if you took what Cook said, if you were a strict constructionist, you couldn't accept a lot of those things Cook said. And yet we have for the last 200 years in our country.
Yeah.
Go ahead.
Yes, and as a matter of fact, there is an image of Edward Cook on the bronze doors into the Supreme Court chamber.
That's right.
Have it removed. Replaced with
There'd
Stephen
be at least
Langton.
one vote for that.
Can I jump into that?
Yeah.
This goes to the reason I went like this earlier and was skeptical about the British Constitution. There are two ways that you can change with the times, legally speaking. You can change the law, or you can change the interpretation of the law. And there are two different ways you can go with that. Now, there are advantages and disadvantages to our Constitution versus the British Constitution, in scare quotes, that is basically whatever they say it is at any particular time. Their system is far more flexible than ours. It's very malleable. They can change very big things about their system of government, basically with a majority vote in the House of Commons. 1999, they got rid of all but 92 hereditary peers in the House of Lords. Boom, like that. All they needed was a Labor majority to do that. So, Lord, whoever, your family's been sitting in the House of Lords for 700 years, too bad. They created a Supreme Court. They hadn't had one. They created an entire branch of government, basically, like that. Vote in the House of Commons. We have only amended our Constitution 27 times, and 10 of those amendments were done in the first 2 years, right? So it's a very, very different way of proceeding. What we have to do, if we want to change with the times, is to see things in our Constitution that nobody knew were there at the time. And that's really where the argument over the Constitution ends up.
That's right. Your question.
The seeds and evolution you've described of the limit of power on government through English, this history and consequent colonial and American culture. Are there any other examples of this throughout the world of a people or a government submitting to such limitations? Or is this sort of a unique English culture thing?
It wasn't unique at the time, in fact. The period of the early 13th century was a period when a lot of charters of liberties were being issued. You can see them in Spain at the time, in Poland. So this was a trend around Europe at the time. The thing is that all the others basically went by the boards. The English one is the only one that remained salient. So it was the sort of lone survivor of a trend that was very operative.
I will add to that. I mean, from my point of view, as a judge appointed for life who can do whatever I think is right, You know, I see foreign judges who come to visit in Washington, and I try to describe our American system of justice to them. And they all have great constitutions, and they all have lots of things on paper that sound terrific. But push comes to shove, if they can be replaced by the king or the ruler of the country easily, it has to affect how they rule in cases. We've never impeached a judge in our history for how they ruled in a case. We've been fortunate. There was an effort to do it one time with the Supreme Court justice. It failed. And we've never impeached a judge because of how they ruled in a case. They have only been impeached when they got in some other trouble. As we know, sometimes that happens. But judges are free to do what they think is right. And it's an independence of our judiciary that really doesn't exist in many countries, so that whatever they have in their constitution, or whether they have something like the Magna Carta, is really less important than the way their judiciary functions and whether it has independence. So from my point of view, one of the most important things of our system of justice and separation of powers that started with the Magna Carta and empowering judges to decide when the king is violating the law, our system of justice ensures that we have that independence, which I think is one of the geniuses of our system.
Can I add, as an appendix to that, the place where I would start to look for the explanation, because I was thinking about this as you were talking, and it's very marked difference in systems, is that all of continental Europe in the Middle Ages and early modern period ends up following the Justinianic Code, which also gets shipped out to weird places like South Africa and so on. And it's an autocratic system. It's a system that operates very top-down, where the English system, if we can talk about their constitution being flexible now, you know, what was it back in the Middle Ages? It was, you know, kings negotiated with barons. There were frequent rebellions and civil wars, not as bad as the Spanish, but and there were moments of autocracy. But in the end, the whole legal system is founded on judicial precedent, really. You know, so there must be something in that that explains why this particular Charter of Liberties lasts, and not just that England had better librarians who kept copies.
I think that's right. Yes, sir.
That's sort of along the lines of the question I was going to ask, which would be, given the fact that during this period, you know, of late medieval history, there were a lot of people trying to use law for different purposes. I've read that the rulers were typically fostering the start of the study of canon law and fostering the origin of the universities, in part to use the rule of the church's law to help justify their own rule. But what was in it for the English barons at this time that caused them, even though bad King John, as we call him, was so very bad, what do you think prompted them to turn to law in this case, as opposed to the usual solution, which was to go sack his castles and burn and choose another king the old-fashioned way?
I've written on this. You know, I thought it suitably obscure, but you've asked the question, and the difference is the English develop, and you don't see this anywhere in continental Europe, a literature of complaint that is founded on law. And so the way you complain about a monarch is with legal texts. And you know, that tends to be the focus, and you also produce legal texts as part of that. And so I study what are called Anglo-Norman legal apocrypha. If that doesn't put you to sleep, nothing will. And what that means is texts whose authority is unknown and produced in the post-conquest period. And there are forgeries and frauds, and they are loved by the English, and especially after Becket, the English who are resentful of the king, I think it's the bishops, are making copies of these and then using them to argue their cases. Not in the sense of they're citing it, but they're getting fuel to the fact that things, if the king is going to point to the past and say, that's the way I am, we have the evidence against him. So that's how they begin to complain to monarchs. And I think that actually plays in. The text I mentioned earlier, the Laws of the English, the Leges Anglorum, is produced in 1206 probably. And it's people, some of the same people involved in the Magna Carta debate have chosen the vehicle of this huge compendious list of all the laws of England translated into Latin, into which they've inserted principles that they want to govern things. That is their big strike. It doesn't go anywhere. And then you end up with the developments in the Civil War and Magna Carta.
Let me just add to that, that Once King John repudiates Magna Carta, the barons do choose an alternate claimant to the throne. They actually offer the throne to Prince Louis of France, who is the son of the King of France, who had had the whole conflict with John in the first place. And they invite Prince Louis of France onto English soil with a French army and attempt to depose King John. So if you're not going to follow the law, we're going to replace you. And that's something that the English do repeatedly. And the last time they do it is with the Glorious Revolution. And when James II, the Stuart king, is deposed, and one of the reasons that he's deposed is because he interferes with the independence of the judiciary. That's one of the things that really, it's a straw that breaks the camel's back when he tries to fire justices for ruling against the king.
One last question over here.
Yeah, hi, Elaine Middleman.
Elaine.
Hi, Judge Lamberth. Former Chief Judge Lamberth, I should say. I recently was in a conversation with another lawyer. The Supreme Court has a case called Garcetti, which limited employee speech under the First Amendment. And this lawyer just had argued a case in the Connecticut Supreme Court, and I was reading about it, and the Connecticut judges said, well, we're going to have a higher standard than the federal. And I just thought that was pretty shocking. And I was wondering if the Magna Carta made some distinction between state constitutions and laws and federal.
In its origins, no. I mean, because it is just a statement about the realm, however fuzzy its borders. How it gets used, I don't know. I mean, is there anything about state interpretations versus federal interpretations or uses of Magna Carta?
Not that I'm aware of. I mean, when you think about, I mean, this is more broadly about state versus federal law. I mean, one of the metaphors that's used is that the state can set a higher ceiling but not a lower floor. So a state can give rights beyond what the federal government requires but can't set the level of rights lower. So this is more responding just to how this happens in U.S. law. But I think it happens because we have this strong tradition of states' rights and that states are sensitive about what they're let alone to do.
Good. Well, on behalf of all of us in the audience, I want to thank Rob and Jenny and Bruce for a very enlightening discussion. I also want to thank all of you hardy souls for showing up on a night like this. So I commend you for being here. I didn't think there'd be that much interest in Magna Carta, so I'm glad to see you all here.
He had an ex-wife, and he made Isabel of Angoulême and the first wife live together under the same roof. That was the sort of charming fellow he was. When Isabel of Angoulême, when King John died, Isabel of Angoulême returned to France, never mentioned King John again, and married the son of the original fiancé. Not joking, really happened.